Hi and welcome to Beazley Boorman Lawyers. Today we are going to look at disqualified driving offences in New South Wales.
G'day and welcome to beazleyboorman.com.au. My name is Joshua Boorman and I am a Sydney traffic lawyer, and I want to have a chat to you about a matter that I had in the Downing Centre local court just this morning, this being early September 2015. Basically, my client was in a very serious situation. It wasn't an alcohol-related traffic offence and it didn't involve drugs, but what it was is he had a series of drive whilst disqualified offences against his name. He has previously driven on a suspended driver's licence and a disqualified driver's licence, and then in court today he had an additional two drive whilst disqualified offences, including an additional breach of a Good Behaviour Bond for a previous drive whilst disqualified. So basically, my client's issue was before the court was that he basically could not obey court orders, and he kept disregarding the law by continuing to drive in his car when he knew that his licence was disqualified. If we take a step back, pointing out that in relation to a disqualified driving offence and a suspended driving offence, there is a fairly big difference between the two. When your licence is suspended, that means that it is either suspended by the RMS or the police. And that means that you're not allowed to drive because your actual driver's licence is suspended for a period of time, or until the court decides as to what should happen to your licence. The difference between a suspended licence and a disqualified licence is that basically a disqualified licence is where your driver's licence is absolutely disqualified, it is cancelled, it no longer exists. It's not just temporarily suspended, but it is completely cancelled out. And it is the court, which is the only one that has the ability to disqualify a person's driver's licence. And basically, suspended driver's licence means that it can automatically be reactivated once the RMS or the police take that suspension away, whereas a disqualified driver's licence, which is issued by the court, means that you need to go back and reapply for a new driver's licence. So your old one doesn't just reactivate, you need to reapply for a whole new driver's licence. So the difference between a suspended driver's licence and a disqualified driver's licence is that a disqualified driver's licence is far more serious than a suspended driver's licence or offence. So basically my client, approximately 18 months ago, was driving on a suspended driver's licence, and that was due to fine defaults. He attracted a 3-month suspension, but he continued to drive. He was then caught driving on a suspended driver's licence and got 2 years off the road. Unfortunately, he continued to drive again, and he, because his licence had been disqualified, was then further charged with a disqualified offence, or drive whilst disqualified. And then in and around May and June this year, within a short space of time, he attracted a further 2 drive whilst disqualified offences. So I give you this background to really explain to you how serious a drive whilst disqualified offence is in the eyes of the law. It is basically showing contempt for court orders when you drive on a disqualified licence. So basically today my client had a breach of a Good Behaviour Bond from the bond that he received earlier this year from the disqualified driving offence, which was issued by the court. He had to also appear on court today for a further 2 disqualified drive offences. Very serious offences. My client was possibly on the verge of having his freedom taken away and serving some real time in full-time custody. But what I was able to do today was bring a bit more of a human element to the court and explain what my client had been going through over the last 12 to 24 months, which has really seen his life spiral out of control. I was able to explain that He owned a small business. A part of that business, it involved him driving around, picking up a lot of supplies and products, and being able to generally operate that business. I was able to explain to the court that he was the sole owner and operator of that business, and that in recent times his business had been failing. He had not been doing well. It had not been earning him a lot of money, and as a result he had become financially and emotionally stressed out due to this business. And subsequently he felt as though he was backed into a corner emotionally and financially, and he felt that this was part of the reason for him making the very poor and foolish decisions that he did by continuing to drive. So I was able to give the court some sort of insight and reason and explanation without making any excuses as to why my client had continued to drive when he knew that his license had been disqualified. What I was also able to explain to the court is why this particular time in court will be different, and what my client has done this time around to ensure that there will be no further reoffending again in the future. I was able to tender evidence to the court to show that my client has engaged the services of a business broker, and he has currently got his business up for sale because it's simply unsustainable without him being able to drive. I was able to tender evidence to show that he's also sold his vehicle, and that there is no longer that temptation there for him just to get into his car and drive the vehicle without a valid driver's license. We were also able to show evidence, a report from a psychologist to show that he had attended a number of counselling sessions to deal with his stress and anxiety, which had been brought about due to his failing business. And ultimately, we were able to tender some references, a letter of apology from him, which did give him, did give my client the ability to show the court that he was very remorseful and apologetic over the actions that had led him to being in this position that he was in today. The magistrate at the Downing Centre did give my client some very stern warnings and indicated that he was on extremely thin ice, and that it was very touch and go whether he gave him a full-time custodial jail sentence today. However, due to the submissions and evidence that we did present to the court, the magistrate did see that it was willing to give him one last opportunity to remain in society and to try and clean his act up. In relation to the breach of Section 9 Good Behaviour Bond, His Honour took it to reactivate or cancel that old bond and put in place a new bond for 2 years. In relation to the second disqualified driving offence, my client received 200 hours of community service. And in relation to the third disqualified driving offence, my client received a 7 months term of imprisonment, which was wholly suspended under a Section 12 Good Behaviour Bond. So ultimately, he will be off the road for quite a long period of time. Automatic disqualification period of 2 years for each offence was applied, and given he had already been disqualified for a period of time, they will add up on top of each other. He will be off the road for quite a significant period of time. And as I say to all my clients and a lot of people out there, it is just not worth disregarding the law or showing contempt to court orders by getting into your car to drive when you know that your license is disqualified, because it can seriously compound the issue. It can show a serious contempt for court orders, and it is a one-way road straight to prison. My client was very lucky to be able to walk out of the courthouse today. The magistrate said that much, said that he was very lucky to have this one last opportunity, and my client was certainly grateful to be able to go home without serving a full-time custodial jail sentence. He certainly learnt some significant life lessons out of all of this incident, and he is going about making significant changes in his life to ensure that there is no further reoffending again in the future. So guys, if you have been involved in any sort of traffic-related offence, disqualified driving, suspended driving, drink driving, these are very common traffic offences within our society. However, they are seen to be very serious offences. either because they pose a risk to the greater community or because they are seen to show contempt for the court and legal system. So they are deemed as very serious offences. If you have been involved in such an offence and you would like to speak to someone to get some professional legal assistance on this, you're more than welcome to give me a call at the office here at Beazley Boorman Solicitors on 02 9283 8622, or you can visit our website where there's plenty of information there on all sorts of offences surrounding traffic laws in New South Wales. And you can visit our website, which is beazleyboorman.com.au. But if you are unfortunate enough to be in a situation where you do need to attend court, happy to have a first free telephone consultation with you, just to give you some advice on what you can expect when you go to court, how to best prepare for your case, and certainly if you'd like to engage us to represent you and provide you with professional legal representation, we will be more than happy to discuss that with you. We do all of our matters on fixed fee prices, very reasonable fixed fee prices, so you know exactly how much you will be in for in regards to your legal costs from the outset, and there'll be no hidden expenses in relation to that. And please feel free to call me on 9283 8622, and I can have a chat with you about your situation. Thanks for tuning in, guys.